One of the signature achievements of our constitutional democracy is the establishment of an inclusive and effective program of social assistance. It has had a material impact in reducing poverty and inequality and in mitigating the consequences of high levels of unemployment. In so doing, it has given some content to the core constitutional values of dignity, equality, and freedom. This judgment is, however, not an occasion to celebrate this achievement. To the contrary, it is necessitated by the extraordinary conduct of the Minister of Social Development, Minister and the South African Social Security Agency, SASSA, that have placed this achievement in jeopardy. How did this come about? The Constitution provides that everyone has the right to have access to social security, which includes, if they are unable to support themselves and their dependents, appropriate social assistance. In terms of its obligations to take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right, Parliament enacted the Social Assistance Act, which makes provision for various forms of social grants. The Act provided for the establishment of SASSA as an agent for the administration and payment of social assistance. The CEO of SASSA is responsible, subject to the direction of the Minister, for the management of SASSA. SASSA may, with the concurrence of the Minister, enter into an agreement with any person to ensure effective payments to grant beneficiaries. On the 3rd of February 2012, SASSA concluded a contract with Cash Paymaster Services, CPS, to provide services for the payment of social grants for a period of 5 years. On 29 September 2013, this court held that the award of the tender was constitutionally invalid in the case of All Pay 1. It subsequently made a remedial order where it suspended the declaration of invalidity, and this declaration was based on the premise that either a new 5-year tender would be awarded after a proper procurement process, or that SASSA would itself take over the payment of social grants when the suspended contract came to an end on the 31st of March this year. SASSA was ordered to report to the court on progress in respect of the new tender process and its outcome. In November 2015, SASSA finally reported that it had decided not to award a new tender, but that it would itself take over the payment of social grants and it would be able to meet the deadline of 31 March 2017. On accepting this assurance, this court discharged its supervisory order, but the assurance given to the court turned out to be without foundation. Since April 2016, the responsible functionaries of SASSA have been aware that it could not comply with the undertaking to the court that it would be able to pay social grants from the 1st of April this year. The Minister says she was informed of this only in October 2016. There is no indication on the papers before us that she showed any interest in SASSA's progress before that. Despite repeated warnings from Advising Council and CPS, neither SASSA nor the Minister took any steps to inform the court of the problems they were experiencing, nor did they see fit to approach the court for authorization to regularize the situation. The Minister and SASSA tells us that CPS is the only entity capable of paying grants for the foreseeable future after the 31st of March. This court and the whole country are now confronted with a situation where the executive arm of government admits that it is not able to fulfill its constitutional and statutory obligations to provide for the social assistance of its people. And in the deepest and most shaming of ironies, it now seeks to rely on a private corporate entity with no discernible commitment to transformative empowerment to get it out of this predicament. In a constitutional democracy like ours, it is inevitable that at times tension will arise between the different arms of government when a potential intrusion into the domain of another is at stake. It is at times like these that courts tread cautiously to preserve the comity between the judicial branch of government and the other branches of government. But there was no constitutional tension about social grants in November 2015. There was no legitimate reason for the court not to accept the assurance of an organ of state, SASSA, under the guidance of the responsible minister, that it would be able to fulfill an executive and administrative function allotted to it in terms of the Constitution and applicable legislation. There was no threatened infringement to people's social assistance rights, and no suggestion that the foundation of this court's remedial order would be disregarded. Now there is. There must be public accounting for how this was allowed to happen. Accountability is a central value of our Constitution. It accompanies the conclusion of procurement contracts for the procurement of public functions. This judgment is the judicial part of that accounting process. It is founded on the commitment to openness and responsiveness the Constitution requires. It is important to note that this particular role, at this particular time, is not one of the court's own choosing. The sole reason for the litigation leading to this judgment is the failure of SASSA and the minister to keep their promise to this court and the people of South Africa. What needs to be understood, however, is that it is not this court's standing or authority for its own sakes that are important. Judges hold office to serve the people, just as members of the executive and legislature do. The underlying danger to us all is that when the institutions of government established under the Constitution are undermined, the fabric of our society comes under threat. A graphic illustration would be if social grants are not paid beyond 31 March. It is to the practical avoidance of that potential catastrophe that we must now turn. Black Sash brings its application in the public interest and in the interest of all grant beneficiaries to seek reinstatement of the oversight role of this court for the payment of social grants. It brings its application to ensure that SASSA complies with its constitutional obligations to provide social assistance in a lawful manner that is in line with constitutional rights and values. Freedom Under Law lodged an application for leave to intervene as a second applicant. It sought to make submissions and obtain relief aimed at further disciplining the process of the proposed arrangement between CPS, the minister, and SASSA. Corruption Watch and the South African Post Office, SAPU, have filed applications to admit it as friends of the court. In a judgment written by myself, in which the Chief Justice, the acting Chief Justice Mogoeng, the acting Deputy Justice, Justice Nkabinde, Cameron J, Jafta J, Kampepe J, Mhlantla J, Mojapelo AJ, Pretorius AJ, and Zondo J agrees, the application for direct access is granted. Freedom Under Law is granted to leave to intervene, and both Corruption Watch and SAPU are admitted as friends of the court. In Allpay 2, the court held that the suspension of the validity of the contract between SASSA and CPS did not prevent the court from regulating and supervising both the content and performance of that contract. It did so on the basis that both SASSA and CPS were organs of state in relation to the contract and that this entailed constitutional obligations for both entities. That this court's remedial power under Section 1721B2 of the Constitution allowed this, and that CPS also bore obligations under Section 8.2 of the Constitution because it had performed a constitutional function for a significant period already. that constitutional obligation persisted to ensure that a workable payment system remains in place until a new one is operational. The constitutional obligations of both SASSA and CPS as organs of state performing a constitutional function for a considerable period do not end on the 31st of March this year. Both SASSA and CPS accept that. SASSA failed to honour its assurance to this court that it will be in a position to make payment of social grants after 31 March. It and CPS failed to timeously conclude a lawful contract to provide for that payment. These circumstances provide a different context for the enforcement of a just and equitable remedy from that obtained when we made the remedial order in Allpay 2. The context then was a breach of the constitutional and legislative framework for fair, equitable, transparent, competitive, and cost-effective procurement. The constitutional defect now lies elsewhere. The primary concern here is the very real threatened breach of the right of millions of people to social assistance in terms of Section 27(1)(c) of the Constitution. It is that threatened breach that triggers the just and equitable remedial powers the court has under Section 172(1)(b)(2) of the Constitution, not only the potential invalidity of the proposed new contract that SASSA and CPS seeks to conclude. The need to intervene under these and similar circumstances was aptly captured by Mogoeng CJ in the Mhlopi case in these terms, and I quote, "It bears emphasis that this is an exceptional case that cries out for an exceptional solution or remedy to avoid a constitutional crisis which could have grave consequences. It is about the upper guardian of our Constitution responding to its core mandate by preserving the integrity of our constitutional democracy. And that explains the unique or extraordinary remedy we have crafted," unquote. This court's extensive powers to grant a just and equitable order also permit it to extend the contract that would otherwise expire on 31 March. Since the contract was declared invalid in Allpay 1, if we extend the contract, it will be necessary to also extend the declaration of invalidity and the suspension of that declaration for the period of the extension of the contract. In Allpay 2, we tied up the suspension of the declaration of invalidity to the period of the invalid contract. That was done in order to allow the competent authority to correct the defect and to avoid disrupting the provision of crucial services that it was constitutionally obliged to render. There was much debate during the oral hearing before us on whether it would be just and equitable to order that those reciprocal obligations should be the same as that of the contract that was to expire on the 31st of March this year. I consider that it should be. No party has any claim to profit from the threatened invasion of people's rights. At the same time, no one should usually be expected to be out of pocket for ensuring the continued exercise of those rights. That equilibrium was the premise of the court's previous remedial order. It is just and equitable to continue on that basis. Our order reflects that SASSA and CPS should continue to fulfill their respective constitutional obligations in the payment of social grants for a period of 12 months as an extension of the current contract. To the extent necessary, our earlier declaration of invalidity of that contract must be further extended, as well as the suspension of that declaration of invalidity. In the event that CPS wishes to alter the content of its financial obligations, the order makes provision for it to approach National Treasury for its consideration and approval, to be confirmed by this court after a report to it by Treasury. My brother Madlanga J wrote a separate concurring judgment And as his judgment shows, there is another valid way of arriving at an identical outcome. In his judgment, Madlanga J accepts that this court has a wide remedial order power to order CPS and SASSA to fulfill their obligation of paying social grants. However, Madlanga J finds difficulty in the convoluted way of first extending the contract, presumably with the extension carrying the original invalidity, and only to then extend the suspension of the declaration of invalidity. Madlanga J sees no bar to making a direct order to the effect that, in terms of the court's wide remedial powers, CPS has to continue paying social grants. The Minister bears the primary responsibility to ensure that SASSA fulfills its functions. She appoints its Chief Executive Officer. There is little that the CEO can do without her direction. Attempts to obtain evidence of what steps she took after All Paid 2 to ensure that beneficiaries would continue to be well catered for drew a blank. These aspects require further scrutiny, but that can only be done after the Minister is joined to the proceedings in her personal capacity and given an opportunity to explain her conduct in relation to these issues. In the result, the following order is made. 1, the Black Sash Trust is granted direct access to bring this application. 2, Freedom Under Law NPC is granted leave to intervene. 3, Corruption Watch, NPC, RF, and the South African Post Office, SOC Limited, are admitted as friends of the court. 4, it is declared that the South African Social Security Agency, SASSA, and Cash Paymaster Services Pty Limited, CPS, are under a constitutional obligation to ensure payment of social grants to grant beneficiaries from 1 April 2017 until an entity other than CPS is able to do so, and that a failure to do so will infringe upon grant beneficiaries' rights of access to social assistance under Section 27(1)(c) of the Constitution. 5, the declaration of invalidity of the contract is further suspended for the 12-month period from 1 April 2017. 6, SASSA and CPS are directed to ensure payment of social grants to grant beneficiaries from 1 April 2017 for a period of 12 months on the same terms and conditions as those in the current contract between them that would have expired on 31 March 2017, subject to these further conditions. 6.1, the terms and conditions shall A, contain adequate safeguards to ensure that personal data obtained in the payment process remains private and may not be used for any purpose other than payment of the grants or any other purpose sanctioned by the Minister in terms of Sections 20 sub 3 and sub 4 of the Social Assistance Act 13 of 2004. And B, preclude anyone from inviting beneficiaries to, quote, opt in, unquote, to the sharing of confidential information for the marketing of goods and services. 6.2, CPS may in writing request National Treasury during the 12-month period to investigate and make a recommendation regarding the price in the contract. 6.3, National Treasury must file a report with this court within 21 days of receipt of the request setting out its recommendation. 6.4, within 30 days of the completion of the contract, of the period of the contract, CPS must file with this court an audited statement of the expenses incurred, the income received, and the net profit earned under the contract. 6.5, SASSA must thereafter obtain an independent audited verification of the details provided by CPS under paragraph 6.3. 6.6, the audit verification must be approved by National Treasury, and the audited verification must be filed by SASSA with this court within 60 days. 6.7, CPS must permit the auditors appointed by SASSA to have unfettered access to its financial information for this purpose. 7, the Minister and SASSA must file reports on affidavit with this court every 3 months, commencing on the date of this order, setting out how they plan to ensure the payment of social grants after the expiry of the 12-month period, what steps they have taken in that regard, what further steps they will take, and when they will take each future step, so as to ensure that the payment of all social grants is made when they fall due after the expiry of the 12-month period. 8, the reports filed by the Minister and SASSA as contemplated in paragraph 7 must include, but is not limited to, the applicable timeframes for the various deliverables which form part of the plan, whether the timeframes have been complied with, and if not, why that is the case, and what will be done to remedy the situation. 9, if any material change arises in relation to circumstances referred to in a report referred to in paragraph 7 or 8, the Minister and SASSA are required immediately to report on affidavit to the court and to explain the reason for and consequences of the change. 10, it is declared that SASSA is under a duty to ensure that the payment method it determines, 10.1, contains adequate safeguards to ensure that personal data obtained in the payment process remains private and may not be used for any purpose other than payment of the grants or any other purpose sanctioned by the Minister in terms of Section 20 sub 3 and 4 of the Social Assistance Act. And 2, precludes a contracting party from inviting beneficiaries to opt into the sharing of confidential information for the marketing of goods and services. 11, the parties are, within 14 days from the date of this order, required to submit the names of individuals with their written consent suitably qualified for appointment as independent legal practitioners and technical experts for the purpose referred to in paragraph 12 below. 12, the Auditor General and any person or persons or institutions appointed by the court after receipt of the names submitted under paragraph 11 shall jointly and until otherwise directed by the court, 12.1, evaluate the implementation of payment of social grants during the 12-month period. 12.2, evaluate the steps envisaged or taken by SASSA for any competitive bidding process or processes aimed at the appointment by SASSA in terms of Section 42A of the Social Security Agency Act of a new contractor or contractors for the payment of social grants. 12.3, evaluate the steps envisaged or taken by SASSA aimed at SASSA itself administering and paying the grants in the future, or SASSA itself permitting any part or parts of the administration and payment processes in the future. And 12.4, file reports on affidavit with this court every 3 months, commencing on a date 3 months after the date of this order, or any shorter period as the legal practitioners and experts may deem necessary, setting out the steps they have taken to evaluate the matters referred to in paragraphs 12.1 to 12.3, the results of their evaluations, and any recommendations they consider necessary. 13, the Minister is called upon to show cause on affidavit on or before Friday, 31 March 2017. Why? 1, she should not be joined in her personal capacity, and 2, she should not pay costs of the application from her own pocket. 14, costs are reserved until conclusion of these proceedings. I hand the judgment down.